Welcome to Behind the Scenes. I'm your host, Hector Montalvo. This show is dedicated to asking tough questions from your government officials and legal officials. Today's guest, coming back for part 2, we have attorney Thomas Mixon and we have attorney Stephen Wright. Thank you guys for joining us again. How are you? In our last show, we were talking about the harassment, criminal harassment orders, where it takes three complaints before a complaint is issued in the court. Today I want to talk a little bit about the effects of the 209A restraining orders, which is basically a domestic relations order. Mr. Mixon, let me ask you, how often do you see these orders, or let's strike that, how do these orders being issued ex parte affect an individual?
Again, there's the two ways to obtain them, either the on-call judge or going before the court and getting a order of protection. Ex parte would be tremendous, especially if you had no knowledge about it. You just, I guess, be coming home from work or whatever it was, and you'd be served this restraining order. You'd be ordered to vacate the premises. Conceivably, there could be an order not to have any contact with your children, certainly not to contact the plaintiff, who usually is the woman in the relationship, although men are certainly entitled to get it as well. And you just have to turn your whole life upside down at that point until the hearing, which should take place anywhere from a week to 10 days later. So you're out of your home.
And if you violate this order, then I'm assuming, what's the longest prison term that if you violate that order, Mr. Wright?
It provides, well,
I think it's a year.
No, 2.5.
Oh, it is 2.5 years. So for 2.5 years on an accusation on a restraining order, if it's violated, that individual could be faced with a 2.5 years prison term?
Right.
And they serve that state or
no, that would be county. There's no
county.
State provision on that. That would be a misdemeanor. The violation is a misdemeanor. But 2.5 years is a lengthy sentence, and I would imagine on a first-time violation, you wouldn't face that. But I mean, any time jail time. Now, let me just back it up for a second. It would only be a violation. The restraining order itself, as you know, is civil. It's only if you violate the terms of it. Now, there's a number of different provisions in these restraining orders, not to contact, not to abuse. There's also a provision for support. Now, I just had a case today that I'm researching where the father had to keep the child's cell phone on for a period of time, and then eventually he let it go. And they brought that back in as a violation, and I'm looking at some cases that say there's only certain conditions that can be considered criminal, obviously if you abuse the plaintiff, but this, along with paying support or anything like that, should not be considered a criminal violation.
Right, so you can get ordered to pay even child support on top of that, not be able to see your children, get thrown away from your home, not have any contact. What about schools? Does that affect the school records that one may be able to obtain? So if you don't have access to your children at home, do you have access to how they're doing in school?
Well, if you're ordered not to contact your children, I mean, you'd have to stay away from the school as well. I mean, you could probably, write to the principal and obtain the records, but until that order is modified, if it says to stay away from the children, that would be wherever they are.
Mr. Wright, what kind of stories do you see coming out of the courthouses with restraining orders, just to obtain a restraining order that you have heard or tried to defend against?
I've had a lot of experience with this, so it's hard to single out. As a general situation, a district court judge faced with the issue of a 209A is not going to get involved in the custody and support provisions unless there's something compelling about it. I don't see it done. I think they say, okay, you got your restraining order, go to the probate court and work out what you're going to be doing with regard to child accessibility and control, child support, whatever. But the impact is, again, heavy because, number one, the suddenness of it, especially if there's no notice or warning. Number two, I mean, it affects different people different ways. Some people are just newly to the area. Do they go rent a hotel room for 10 nights until they can get back in court? Or do they have a friend they can go to? Now, most people would go to a friend, I would assume, but the impact is terrible. The child doesn't see the parent for the 10-day period or whatever it is, and there's an impact, especially on small children, and even on fairly, well, even teenagers are impacted by something like that. I mean, it's economically, it's very, very difficult for the defendant to deal with. He's got to go out and hire a lawyer. If he's got a restraining order, he doesn't know what he can do to defeat it. I mean, as I had said earlier, that the specificity of the time, date, time, and place are very, very important. And again, I think it's important that the same judge get this case back again, and that will happen in the probate court. In the district court, you don't know who you're going to see, and that's why I think most district court judges will stay away from saying child support or custody. Or maybe custody until you can get to the probate court. But I mean, again, the impact is still immense. It's immense on any recipient of the order or any defendant.
So if the restraining order is a civil effect, and they're also being issued from the criminal side of the court system as well as the probate side?
No. But everybody who's in there has a notice with the reference to the 209A that there is a violation, and you could face up to 2.5 years if you violate it. I haven't seen that happen. I've been practicing a long time, but I have seen people go away, and and the judge saying, I don't know what else I can do with this. The second time he's done it, bingo. And
And this would be before having their trial.
Oh, no. It would be after a trial. It would be after a day in court, but it would be after either the order's issued, and now there's an allegation as to a violation of it, and then you've still got a problem if you're the defendant.
Right, especially if you are smart enough to go and know that you can get a restraining order issued from district court as well as from probate court. Now you have two restraining orders. Do the people talk in the court system? Do they have computers to let one court know that one was already issued, so it's not a duplication of a restraining order?
They'll allow the probate court to supersede the district court on the same order, wouldn't you say?
Yes. The problem I'm seeing more and more in the district court, though, is when someone wants to use it to their advantage to gain, let's just say they had an assault and battery, domestic assault and battery, and they got the restraining order. They know that if there's a future violation, even alleged, that there's a chance, and it's becoming a better and better chance, that the defendant could lose his liberty for up to 60 days pending while the case is going on. They call that a revocation of his recognizance. So if you're released on the assault and battery and said, abide by the restraining order, if there's a new allegation, the Commonwealth, through the district attorney's office, on a large majority of these cases, will say, well, we want to revoke this person's recognizance for up to 60 days. And they're held without bail. You could be a millionaire, and you're not getting out of the House of Correction until the matter's resolved, or the 60 days expires.
That could be a violation of due process right there.
That could be. And who's responsible to oversee that? I mean, we have judges. It seems like judges just handling out the restraining orders based on $25,000 to $50,000 a year. I mean, does that number show that there is a need to try to reform that particular law?
I would think so. I would think there's a...
I would think a judge would be, I think I've seen it done, though, where there's an allegation of a violation of a restraining order without due process, and in they come and take them away.
They do.
Yeah, and I think that's a problem.
Yeah, we
That
definitely
violates due
work on that.
process.
And you can't even get a bail review on that.
That's right.
On a normal case, you could get a bail. You could go down to, if it was in here in Lawrence, you could go to Salem Superior.
Yep.
But on the probation violation, that again, if you're on probation and there's an allegation that you violated the restraining order, you're held without bail while the matter's pending.
So even though all these orders, the harassment and the restraining orders, are all civil, they really, in reality, they do hold criminal implications.
Sure,
Absolutely.
any violation.
Absolutely.
Like I said, I haven't seen a violation yet of the harassment orders, but the same penalties apply.
What is one of the biggest abuses that you see in these restraining orders?
Usually, and I don't want to sound sexist here, but a lot of times it will be the female will, if there's some difficulties in the relationship, or she thinks that the boyfriend or husband is cheating on her, they'll allege a violation.
What do you think the percentage would be of the necessity of having a restraining order versus having one that's actually being abused? Do you think it's more being abused versus more people have it to abuse it versus the people that do have it that really need it? Because obviously if these orders are being abused this way, those people that really need the restraining orders, because restraining orders were designed, my belief is they're designed to protect people that are in immediate physical harm, okay? And if that's not happening, then obviously the system needs to be changed.
Everybody's swearing under the pains and penalties of perjury. Like to believe that these are valid, but we know from experience that many of them are not. I think it's impossible to guess what the percentage may or may not be as to what's valid and what isn't valid. The overwhelming argument is, of course, in some cases they are absolutely necessary, and again, I'm being redundant. The judges will err to the conservative, and they'll believe the smaller person sometime if there's alleged violence.
And with the restraining order, again, you don't need the 3 instances of harassment or abuse. So when you think about it realistically, it's usually just the man and the woman in the house, and the woman saying he threatened me or he harmed me or he hit me somehow. And I mean, who else is going to be there to witness it? So.
So that it's all based on an accusation that anyone, well, in this particular situation, you would have to have some type of relationship.
Exactly.
Is that like a live-in relationship, or is it just a boyfriend and girlfriend, or?
It could even be a dating. You wouldn't have to. You don't have to live together.
The court would ask how long has the relationship been going on, but you don't have to be living together.
But then, obviously, the ramifications of that would be less, because if you're not living together, you're not ordered to vacate. You'd probably get an order not to abuse the person. Well, you shouldn't be abusing people anyways, but now to make it a violation, a criminal offense, which it could be anyways. I mean, if if a person strikes another person, that's a crime anyways.
And to give those viewers out there that an opportunity to understand the effect, how much would it run? I mean, basically they would need an attorney to come in and represent them on the restraining order. What would something like this, if a restraining order was to affect an individual, what are they looking as far as expenses wise towards to be able to be represented?
You mean attorney's fees?
Yeah.
It would depend on the attorney's hourly rate and how much time he had to put into it. And some of those you have to put a lot of time in. If you're digging for an alibi, and it can be considerable.
Right.
And then you've got to bring in an additional witness. Again, the other part of the problem is that most people involved in these situations who resort to the court do not have the financial means to protect themselves. And I find that when I've been doing it, that I've accepted less than my usual going rate because I'm concerned with the ends of justice being met, and and I know we've got an alibi. I got to bring it in, and it's as I said, sometimes more expensive than it should be, or I have to charge